and the detention has to come to an end, and you can't keep him detained forever and ever. There has to be a reasonable time for such.
What's the connection with this case?
My lord, the connection is reasonable time. Even in the case of a convicted offender for crimes against the child, he could not be denied of all civil rights, and Australia doesn't have a chapter on fundamental rights, so they talk about civil and common law rights. He couldn't be denied civil and common law rights forever and retained forever. The other common factor is that there was an earlier decision known as your lordship goes through this judgment, your lordship will see, in the case of Katib. In the case of Katib, the Australian High Court had said that that person can continue forever. They revisited it and they said that that declaration was contrary to the Constitution of Australia.
But Mr. Mathur, your submission is that Samiullah Baloch is to be overruled on the ground that there should be a reasonable time rather than unlimited time. And to carve out that reasonable time argument, your submissions are, in summary?
My lord, my submission is that Samiullah Baloch should be overruled because it reads into 62(1)(f) a civil liability, a declaration of a civil nature, which for the life of the declaration disqualifies a person and thereby strips him of his fundamental right under Article 17 of the Constitution. My lord, I have not used the word lifetime now advisedly.
Mr. Makhloom.
Sorry. My lord, so that's the first submission. The court talks of the doctrine of Tawbah, but then and says this declaration will remain in the field till it is so removed, but does not identify a forum or a law under which this declaration could ever be undone. So neither it identifies a statute nor it identifies a forum under which would undo this declaration.
Does not identify forum or
mechanism or the law. A law under which such a declaration can be made and a forum which will make that declaration. They don't identify, because my respectful submission is neither such a law nor such a forum exists.
That means that Samiullah Baloch is talking about a window that is through Tawbah for the purpose of election. Yes. Even otherwise, inter parties, the declaration stays.
Yes.
But they're also realizing that for elections there could be a Tawbah system.
Yes.
But that system isn't really there.
That system is not there, that law is not there.
And the judgment talks about mechanism.
It's not there, and my lord, as my lord the Chief Justice identified, this cannot be looked into without looking at Article 175 of the Constitution. When your lordship examines Article 175, paragraphs 1 and 2, all courts, including this honorable court, has only such jurisdiction as is conferred upon it by any law or the Constitution. And that law is not identified, that constitutional provision is not identified.
You mean to say that no special court has been constituted for 62(1)(f)?
My lord, even under 62(1)(f), if a special court is constituted, it has to be done under a law. There is none. So your lordships and no civil court will have a jurisdiction which is not given to it by the Constitution or the law. So
Section 9 of the CPC is procedural or substantive?
My lord, even if your lordship looks at Section 9 CPC as substantive, a Section 9 CPC code will not, in the face of a decree which is described by, or declaration, I don't use the word decree, declaration which is described by this honorable court as permanent and past and closed transaction, applying the principles of res judicata, will not issue a declaration that this declaration no longer applies to this person.
Is that it? Anything else?
My lord, that is it. And
just one more question. Is there any material which sort of talks about the importance of elections in the sense that people convicted or people having decrees against it, there's this cooling off period and after which they can jump into the ring again? I mean, conceptual framework of this, any material, anything that elections require, that even if you were a convict after a cooling off period, you're still, I mean, democracy requires that you come back into the ring again.
My Lord, history gives you that example, which I gave your Lordship 2 examples very recently, that history gives you that example. Besides history, I haven't come across, but I'll look for it. My Lord, my last submission was, and that's the formulation, that it was submitted yesterday by one of the amici, that your Lordships will make this judgment, he didn't say that in so many words, prospective, and it will apply only now to the current election disputes, but it will not do anything about people who had earlier been disqualified as a result of Samiullah Baloch or earlier case law. The submission over there would be that if your Lordship was to go down that road, your Lordships will be creating two classes of citizens in the country, those in whose case a declaration has been made earlier and they have been stripped of their fundamental rights, and those whose fundamental rights are threatened now.
एक चीज मखदूम साहब इसी से रिलेटेड जो सवालात हो रहे हैं जी, जो समीउल्लाह के केस में आया है वो ये आया है कि जब तक वो डिक्लेरेशन कायम और दायम रहेगा, जब तक उसका डिस्क्वालिफिकेशन रहेगी। अब ये जो नया लॉ 232 में आया है, कैन वी रीड इट लाइक दिस कि ये जो वो वाली बात थी वो उन्होंने परमानेंट नहीं कहा, उन्होंने कहा एज लॉन्ग एज द डिक्लेरेशन विल रिमेन इन फील्ड। हम ये कह सकते हैं कि इस लॉ के आने के बाद उस डिक्लेरेशन की मुद्दत उन्होंने 5 साल कर दी।
सिर्फ इलेक्शंस।
Yes, my Lord, your Lordship
to the
may,
extent of election.
Your Lordship may, but my respectful submission remains. My respectful submission remains that your Lordship.
You are very hesitant to go that path.
My Lord, I spent several days unsuccessfully arguing in another case, so I'm in a way, I have got a mental block saying that a statute, my Lord, your Lordship's judgments are there. Your Lordship will find every reason to uphold the validity of a statute. Even only when reasoning completely fails your Lordship, would your Lordship strike it down. When there are two interpretations possible, your Lordship will give an interpretation. The burden of proving a statute unconstitutional is upon the person who comes to this honorable court and says the statute is unconstitutional. Now, in order to apply those, now even if your Lordship is to uphold the statute,
it was just a comment.
No, my Lord,
with your.
No, but one more question which arises from that is that there's a bit of an unease when we look at 232. Can, through sub-constitutional legislation, the constitutional provision be controlled? I just want your comment.
My Lord, my submission is to.
Maybe we have just considered this very point in the Supreme Court Practice and Procedure
Yes, Your
Act,
Lordship.
which was a full court where the right of appeal was created by a statute, not by the Constitution. Is that an answer or not an answer?
My Lord, that's one answer, and your Lordship gives another answer in that case as well, where your Lordship.
That judgment is binding on us.
That, and your Lordship says that we will not deal with academic questions. Questions which do not arise, we will not decide in this case. Number of issues were raised. Your Lordship's in the penultimate paragraph, Practice and Procedure Judgment.
Yeah, it was very interesting hearing. It was,
your Lordship,
we would have loved to, but like you said save it for another day.
Yes, my Lord, and I would therefore say, my Lord.
Can you also just, I know it may be imposed, give a little write-up today?
My Lord,
not too long,
ready?
just precise what you formulated, so we don't want to miss anything out.
Before leaving the rostrum,